All right, so next up, we're going to talk about IMAV Realty, its independent associate agreement. So, IMAV Realty, independent associate agreement, this agreement made and entered into the date hereof by and between IMAV Realty, hereinafter referred to as broker, and blank, hereinafter referred to as associate. So that's where the second blank is where you would put the name of your agent. That's your onboarding. Witness, whereas broker is now engaged in business as real estate broker in the state of Arizona and is duly licensed to sell, offer, for sale, buy, offer to buy, exchange, list, or solicit prospective buyers and sellers to lease, rent, or offer to lease or rent and negotiate the sale, purchase, or exchange of real estate. The broker does not participate in cemetery or timeshare properties. So right away, we know that this company, IMAV, does not do cemetery and we don't do timeshares or transactions of property management. So we don't do commercial, we don't do property management, we don't do cemetery, right? And we don't do timeshares. Sorry, we do commercial from time to time, but we exclusively don't do cemetery, timeshares, or property management. Those three. But we do residential, and time to time we'll do commercial from time to time. The broker does enjoy the goodwill of the public and a reputation of fair dealing with the public, whereas broker may maintain offices in said state, possess equipment necessary and incidental to the operation of said business suitable to serving the public as a real estate broker, and whereas associate is now engaged in business as a real estate licensee duly licensed by the state of Arizona, and whereas it is deemed to be mutual advantage of broker and associate to enter into this contract upon the terms and conditions hereinafter set forth. Now, therefore, for and in consideration of the mutual covenants and promises herein contained, and each act done pursuant hereto, the undersigned hereby enter into the following articles of agreement. Article 1, independent contractor. A. So this agreement does not constitute a hiring by either party. The parties hereto are and shall remain independent contractors bound by the provisions hereof. Associate is licensed by state law and is under the broker as to the result of associate's work only and not as to the means by which such result is accomplished. The agreement shall not be construed as a partnership, and neither party hereto shall be liable for any obligation incurred by the other except as provided elsewhere herein. The broker shall not withhold from associates commission any amount for taxes by any government entity. The broker shall not make any premium payments or contribution to any workman's compensation or any other government entity or associate. Effort. A. Associate agrees to proceed diligently, faithfully, loyally, legally, and with the best efforts to promote the business of serving the public to the end that each of the parties hereto may derive the greatest benefit possible under the laws of the state of Arizona, and more importantly, must be fair and equitable to all parties in any transaction. Article 3, Ethics and Trade Organizations. It is expressly understood that broker of IMAV Realty is a member of the National Association of Realtors Arizona Association of Realtors, and any local real estate boards and multiple listing services. That any associate producing more than 6 transactions per year deemed necessary for broker to join. As a result thereof, broker and associate are subject to agree to abide by the rules and regulations of those organizations, and related organizations pertaining to ethics, conduct, bylaws, and procedures. Agent agrees to, within 10 days of commencement of this contract, will become and remain a dues paying member of an approved association of realtors and MLS in the state of Arizona. So basically, this says if you do more than 6 transactions um, uh, in a certain county, like say TARS, Tucson, Arizona Realtors, then the broker needs to become part of that brokerage or part of that organization. All right, associate and broker each agree to conduct business and regulate habits and working hours so as to operate in harmony with current laws, policies, and rules and regulations as set forth by the Arizona Department of Real Estate, ADRE, as well as to maintain and increase the goodwill, business profits, and reputation of broker and associate. Article 4, Commissions. A. The commissions and fees for services rendered in the sale, purchase, rental, lease, or exchange of real estate shall be those mutually agreed to by broker and associate. In no event shall associate charge less than the minimum commission fee established by the broker without broker's prior written consent. Commission and fee, when earned and paid pursuant to this agreement, shall be paid only by the broker to associate and or referral according to the commission schedule defined for this individual attached hereto. So again, who pays you? Your employing broker, not just any broker, right? Not the broker up the street. It's your employing broker, and that's the only person you can accept compensation for. In the event that more than one associate under contract with the broker participates in a common sale and multiple claims are made for a commission hereon, broker will refer to the written instructions submitted by the associate whose name appears on the controlling document, i.e., listing and or sales contract, to determine how to contribute funds in the absence of any written instructions or as the result of any ambiguity in the terms of thereof. The broker shall have the right to determine in his sole discretion how the commission in question will be shared, if at all, among the claimants. In no event shall broker be personally liable to associate for any commissions not collected. Article 5. The broker shall not be liable for any expenses incurred by associate or for any of his or her acts, including but not limited to errors and omissions deductible, the expenses of attorney fees, costs, life, title abstracts, and the like, which must, by reason of some necessity, be paid from the commission or are incurred in the collection of or the attempt to collect the commission shall be paid by the associate. Article 6. Real estate license, bonds, and dues. Associate shall pay all costs associated with the maintenance of his or her own real estate license and or any associate fees unless otherwise negotiated. Article 7. Authority to contract. A. Associate shall have no authority to bind, obligate, or commit broker by any promise or representation unless specifically authorized by the broker in writing in a particular transaction. Associate shall be and is hereby authorized to execute contracts of sales, purchase, rentals, and leases, and listing agreements for and on behalf of the broker as agent af- after certificate to write contracts has been issued by broker. Also, 3 hours of contract writing class must be earned from a recommended accredited school of real estate. Article 8. Listing correspondent records and forms. Associate agrees that any and all listings or contracts of property and all actions taken in connection with the real estate business shall be taken by associate in the name of the broker. Right? So everything you do is pretty much in the name of the broker. Completed listings or contracts shall be filed with the broker no later than 3 business days after commencement of contracts or listings by associate. All listings or contracts shall be and remain the separate and exclusive property of the broker unless otherwise agreed by the parties hereto, and listings or contracts received by the broker and exceed the 3 business day rule will be subject to a $250 penalty, which will be deducted from associate's next commission to be received. If no commission is received within 30 days, associate must pay a $250 penalty. Associate must give a broker a complete copy of completed transaction for broker's file. An associate must keep a completed transaction file within 3 days of class of escrow date. List of completed transaction attached as exhibits A through D. B. Bravo. It is agreed by the parties hereto that all correspondence, documents, or information of any nature whatsoever concerning transactions handled by broker or by associate or jointly are and shall remain the property of the broker. C. The parties hereto shall mutually approve, and agree upon all correspondence from the office of the broker pertaining to transactions being handled to whole part by associate. D. The parties hereto shall mutually agree upon the forms to be used and the contents of all completed contracts and other forms before they are presented to clients for signature. Each listing or contract submitted to broker shall have the applicable listing check sheet or purchase check sheet or any other check sheet provided by a broker. Provided by IMAV Realty, filled out completely with the appropriate documentation attached. No commissions will be paid to the associate before all documentation needed for each file is received and approved by broker or coordinator appointed by broker, or by the end of the rent next business day into an escrow account of a bona fide title or escrow company. Associate shall secure a receipt or copy of the same for immediate delivery to broker on all deposits. Also, associates shall deliver, fax, or email and receive confirmation of delivery to client. No earnest monies and or deposits will be taken in the name of IMAV Realty. Article 10. Cancellation of listing, sales, and other transactions. Broker shall have the sole right to cancel any listing agreement or any other transaction on any property at any time by written notice to associate and the seller, provided associate is in default of any term of this agreement or this agreement is terminated. So if the broker wants to cancel the deal, he can do it at any time for any reason. Litigation and controversies, Article 11. In the event that associate does not wish to orally enter into the following actions jointly with broker, then associate hereby grants to the broker that power of attorney in his name, place, and stead to institute and or defend an action in a court of competent jurisdiction concerning commissions or other matter related to the conduct of such real estate business of broker and associate as have been pursued by the parties under this agreement to conduct the same to a final decision, to negotiate settlements, to defend actions, suits, or proceedings pertaining to said real estate business, to employ counsel and to conduct said matters in final consummation in such a manner and upon such terms as the broker may deem expedient or desirable. Part B, in the event any transaction in which associate is involved results in a dispute, litigation, or legal expense, associate shall cooperate fully with the broker, whether associate is with IMAV Realty or whether associate has left IMAV Realty. Suits for commissions shall agreeable to the law default and hold harmless. The parties hereto mutually agree that if either party shall be in default of or breach any of the terms or condition of this contract, and such default or breach shall result in any loss or damage to the other party, then in that event, the defaulting party hereby to pay to the other party any such loss or damage, and further agrees to hold harmless from any claim, demand, cause of action, or lawsuit which may result from or be caused by such breach of this contract. There is hereby granted to the defaulted party a contractual lien upon any sums due or owing to the other, or which may be collected by the defaulted party and subsequently be due or owing to the other party, to cover the items described in this article. If said sum shall not be liquidated in amount, then in that event, the defaulted party is authorized to retain said sums until said claim, demand, or cause of action shall be consummated. Article 13, Arbitration Agreement Procedure. In the event of disagreement or dispute between associate and broker rising out of or connected with this agreement, which cannot be adjusted by and adjusted the parties involved under the terms and conditions of this agreement, and involves a dollar amount in excess of the legal maximum allowable for suit in small claims court, the parties hereto agree to submit such disagreement or dispute to arbitration in accordance with the rules, regulations, and procedures of the American Arbitration Association. Associate hereby agrees to pay all costs in connection thereto, and be bound by the decision of the arbitrator named by the above described arbitration body. Article 14, Automobile. It is agreed that associate shall furnish his own automobile and pay all expenses thereof, and that broker shall have no responsibility therefor. The associate agrees to carry an adequate amount of public liability insurance with minimum limits of $100,000 for each person and $300 for each accident, and with property damage limits of $100,000. The broker shall be shown as an additional named insured in all policies. Associate agrees to furnish to broker a copy of the declaration page, certifying as to such insurance prepared by the insurance company within 5 consecutive days of agreeing to this agreement. No commissions will be paid until declaration page showing broker as additional named insured is provided. Termination. This agreement and the relationship created hereby may be terminated by either party hereto with or without cause at any time upon written notice given to the other. But the rights of the parties to any commission or fees which accrue prior to said notice shall not be divested by the termination of this agreement. except as stipulated herein. A 30-day consecutive day notice in writing by the associate or broker shall be noticed. If an associate is in violation of this agreement, in violation of state laws, rules, regulation, policies, in violation of the Realtor Code of Ethics, or any Realtor Association rules, regulation, or policies, the broker may terminate immediately. Upon termination of this agreement, all negotiation or contracts commenced by associate during the term of this shall continue to be handled through broker and with assistance by associate as is reasonable under all the circumstances. Upon termination of this agreement, associate may preserve his or her right to receive commissions as outlined in this agreement by remitting the administration fees in the amount and by the due dates contained in the applicable commission schedule for the duration of any pending transaction in which associate has established an interest. If for any reason associate fails to act in accordance with the terms of this agreement, or it is otherwise determined by broker that associate unable to act in accordance with the terms of this agreement, then associate will be in breach of the agreement and thereby causes his or her waiver of all rights to commission otherwise payable by associate had the breach not occurred. In case of breach by associate, broker may in his sole discretion assign the transaction to another associate, assignee, to service the transaction to its final outcome. In the event all commissions less those amounts due broker from defaulting associate may be paid to assignee subject to the terms of assignee's commission schedule or will be determined by the broker. Upon termination of this agreement, associate agrees not to furnish to any person or entity engaged in the real estate business any information concerning broker and or his or her business. All listings initiated by associate shall be screened separately and individually and may be released or canceled by broker. Article 16, miscellaneous. Heirs, successors, and assigns. This agreement shall be binding upon, and the benefits shall ensure to the heirs, successors, and assigns of parties hereto notices. All notices provided for under this agreement shall be in writing and shall be sufficient if sent by regular mail to the last known address of the parties hereto or to such other address as shall be designated in writing to the other party. Governing law. This agreement shall be governed by the laws, rules, regulations, and policies of the state of Arizona. Assignment. This agreement may not be assigned, sold, or otherwise conveyed by associate without broker's prior written consent, but may be assigned by broker to any successor of his business. Waiver. That the failure of any party hereto to enforce at any time any of the provisions or terms of this agreement shall not be construed to be a waiver of such provisions or terms, nor of the right of any party thereafter to enforce such terms or provisions. Entire agreement. That this agreement constitutes the entire agreement between the broker and associate, and that there are no agreements or undertakings concerning such agreement which are not fully set forth herein. Severability. That if any provisions of this agreement are invalid or unenforceable in any jurisdiction, the other provisions herein shall remain in full force and effect in such jurisdiction and shall be liberally construed in order to effectuate the purpose and intent of this agreement. And the invalidity or unenforceability of any provision or durability or enforceability of any such provision in any other jurisdiction. References. That all associates shall provide at least 2 separate individual references for emergency use with correct and current addresses and phone numbers with this mutually signed agreement. Amendments to this agreement, that there may be amendments to this agreement if in fact there are changes in state laws, rules, regulations, or policies. If there are changes in realtor ethics, rules, regulations, or policies, there may be changes between broker and associate if there is mutual agreement to do so. Article 17, Errors and Omissions Insurance. The errors and omissions insurance carrier shall be chosen at the sole discretion of the broker. Associate is responsible for the deductible amount. Currently, it's $5,000 for each errors and omissions claim based on the commission split at the time and transaction the associate was receiving fees. For associate shall immediately notify broker of any circumstances like to give rise to a claim of any kind. In the event of any claim, lawsuit, license, complaint, or arbitration demand which is not wholly covered by IMAV Realty E&O Insurance, associate is responsible to satisfy any amounts not covered. Brokers may also deduct the aforesaid amount from associate commission. Associate agrees to reimburse and indemnify broker for any and all attorney fees incurred by broker to obtain legal advice concerning such transactions. If there is an outstanding amount owed to the broker, the associate will allow broker to file a notice of default in the county and the state in which the associate lives. Whereas both parties, broker and associate, agreeing to the above agreement are declaring that they are of full and sound mind. Article 18, Additional Miscellaneous. Independent contractors. As an independent contractor, agents are not required to do floor time or required to attend any sales meetings. All agents are independent contractors and are responsible for all their own business expenses, such as advertising, business cards, yard sign installation costs, lock boxes, open house signs, MLS, and licensing fees, etc. In the event the company incurs any expenses on behalf of the agent agrees to reimburse the company immediately upon presentation of any invoices. Teams. A team is defined as a lead agent, team leader, and at least one licensed agent working as a team member. A team commission agreements are to be made based on mutually agreed upon terms between the team leader and the team members. These agreements should be in writing and carefully considered to ensure compliance with all federal, state, and local laws as well as company policy. Team commission agreements must be on file with the broker. IMAV Realty will not intervene in any disputes between team and members and team leaders. Assistants that are unlicensed, legal activities of an unlicensed personal assistant. So here's unlicensed assistants. Employment of a personal assistant who will be providing services that do not require a license is called an unlicensed assistant. Is at the broker's discretion. Unlicensed assistants may answer phone calls, fill out and submit listings, follow up on loan commitments after a contract has been negotiated, and generally secure status reports on the loan progress, assemble documents for closing, secure public information from courthouses, utility districts, have keys made for company listings, write ads for approval by the licensee and broker, and place classified advertising, monitor licensees and personal files, compute commission checks, and place signs on property. Prepare flyers and promotional information for approval by the licensees and broker, deliver documents, place pick up keys, place routine telephone calls and late rent payments, schedule appointments for the licensee to show listed property, gather information for a comparative market analysis, hand out objective written information on a listing or rental. Unlicensed assistants may not make cold calls by telephone or in person to potential sellers or purchasers, show properties for sale, and or lease to prospective purchasers, host public open houses, host licensee open houses, home show booths or fairs, answer any questions concerning properties listed with the firm except for the information contained on the listing agreement as limited by the broker, prepare promotional material or advertising for properties for sale or lease without the approval of the broker, discuss or explain listings, offer contracts, or other similar matters with persons. Outside of the firm, be paid on the basis of real estate activity such as percentage or commission or any amount based on listing sales, etc. Act as a go-between with the seller and buyer, such as when an offer is being negotiated, negotiate or agree to any commission split or referral fee on behalf of a licensee. So, assistants that are licensed. If you have a real estate license, what can you do? Well, licensed assistants are bound by the same listing agreements as an agent, including but not limited to executing an independent contractor agreement, fully associating themselves with IMAV Realty, paying all fees associated with and following all policies and procedures of IMAV Realty. Licensed assistants may only assist other IMAV Realty agents, not work with any agents outside of IMAV Realty. Additionally, any licensed assistants or transaction coordinators must have their license affiliated with IMAV Realty. Agents may use a third-party transaction coordinating company with only the broker approval. All licensed assistants must be paid through the broker. So name tags, while in the office, agents are requested to wear their name tags for IMAV Realty office staff to distinguish agents for their safety and their security of the facilities. While wearing name tags is not mandatory in public places, a name tag can be a viable marketing tool. Absence or unavailability, agents who are leaving the area due to family emergencies, vacations, etc., or are otherwise unavailable to conduct their business. They must employ the services of another IMAV Realty agent in their absence. They must inform management of their absence and provide the name of the agent managing their business. If the company is unable to reach an agent within one business day, the company will reassign the transaction until the agent becomes available and will collect an additional 25% of the commission. It's big time. Property management. IMAV Realty agents are prohibited from engaging in any form of property management. So again, here at IMAV Realty, we don't do timeshares, property management, or cemetery. But from time to time, we may do commercial property. Timeshares, agents are not permitted to list timeshares due to the unique nature of timesharing. IMAV Realty does not market this form of real estate. Commercial and business transactions. IMAV Realty agents are never permitted to practice any form of real estate outside their area of competence, as directed by Article 11 of the Code of Ethics. Prior to engaging in any commercial or business transaction, agents must submit a resume to the management which defines their commercial expertise. Agents without commercial and business expertise who have the opportunity to be involved in a commercial or business transaction are required to team up with an experienced company commercial agent. Additional notes: E&O insurance does not permit business-only transactions. All agents are on an 80% split in regard to all commercial and business transactions. All commercial agents are required to be a member of a commercial board. Discrimination. IMAV Realty is fully committed to fair and equitable treatment of agents, employees, customers, and the public at large. The company has a zero tolerance policy toward discrimination. The company requires adherence to all laws and ordinances that provide protection of civil rights, including but not limited to the Civil Rights Act of 1866, the Fair Housing Act, Title 8 of the Civil Rights Act of 1968, the Americans with Disabilities Act, the Arizona Landlord Tenant Act, the Equal Credit Opportunity Act, (ECOA), the Truth in Lending Act and regulations, the Real Estate and Settlement Procedures Act of 1974, RESPA. Expectations: management, agents, and employees must treat customers, the public, and each other with the utmost respect, dignity, and fairness. Harassment: IMAP Realty takes all forms of harassment seriously, including but not limited to verbal, physical, or sexual harassment. Reporting and consequences: all reported or suspected occurrences of harassment will be promptly and thoroughly investigated. Any agent found to have harassed another agent, employee, client, customer, or any member of the public will be immediately and without warning released from the company at the company's sole discretion. If an agent feels harassed, they should notify the broker or a member of the corporate team immediately. The policy here is the company will not condone or permit acts of retaliation against anyone who files harassment complaints or cooperates in investigations. Broker advertising: the brokerage reserves the right to advertise any company listing at company expense. If the company-sponsored advertisement generates a prospective customer, the company may refer the prospective customer to any IMAV Realty agent with the expectation of a referral fee. Listing protection: other than broker advertising, all inquiries received from buyers or other realtors will be immediately forwarded to the listing agent. No other agent will be able to interfere with another agent's listing contacts. IMAV Realty staff are not permitted to provide showing instructions. All inquiries are forwarded to the listing agent who is responsible for that listing. The minimum listing term of all listings is 3 months. The minimum co-op commission when offered on the MLS is 2% to the co-op agency. Commercial listings are exempt. Listing commissions are negotiable. Refer to the commissions paragraph for specifics. All listing agreements must be signed by all persons who have an ownership interest as evidenced by a deed, title policy, closing statement, or other type of instrument. In most instances, agents will be allowed to cancel a listing at any time or take the listing with them when changing companies. However, this should be discussed with the broker prior to make these changes. Listings that are under contract must stay with the company. So say you have a listing and you get an offer and you accept the offer and it's under contract, that's got to stay with the company. But if you have a listing, it's, there's no offer, it's not under contract, it's not an escrow, you can take that with you. Escrow: IMAV Realty does not maintain an active escrow account. Instruct your buyers to make their escrow checks payable to the title company. Agents are still responsible for assuring that all escrow deposits are made in a timely fashion. All initial deposits must be submitted for deposit by the next business day, and all additional deposits must be submitted according to the date specified in the sales contract. Additionally, agents must submit a written request, receipt of escrow form to the title company or attorney to provide written verification of receipt of the deposit. A copy of the receipt of escrow's form must be uploaded into paperless pipeline with the other initial sales documents in accordance with the required document checklist. If the form is not received, you will receive a $25 service fee. Time is of the essence. Agents must forward copies of escrow checks to paperless pipeline. Failure to follow correct procedure will result in severe consequences and possible repercussions with ADRE. Standard contracts: IMAV Realty uses standard AAR contracts, Arizona Association of Realtors. These contracts should be submitted together with required documents in accordance with the IMAV Realty required documentation checklist. Agents must download and use contracts from Transaction Desk and always ensure they are using the most current version. To minimize potential liability, agents should diligently review the forms library on Transaction Desk and avoid using photocopies or previously saved forms. Listing and sales administration. The brokerage is required to supervise all transactions. Failure to supervise agents and transactions is a serious violation and jeopardizes the broker's license. The brokerage is required to produce any listing or sales file upon demand whenever the Arizona Department of Real Estate (ADRE) requires. Listing and sales files must be received within 3 business days of the effective date of the listing sales rental contract. IMAV Realty shall assess a $250 fine to any agent when a sales or listing file is late. Late rental leases or rental listing files will be assessed $50. Repeated late files may result in termination of the agent and could require the broker to report the agent to the Arizona Department of Real Estate for further action. IMAV Realty will send a receipt by email to the agent when a file is received. Rejected offers. ADRE requires IMAV Realty to keep all rejected offers for a period of at least 1 year. In order to comply with this rule, we have set up an email to collect these rejected offers. Agents must email all rejected offers to mjthomp3@gmail.com within 48 hours of the offer being rejected. So if you get a rejected offer, or if you reject an offer, just you got 2 days. Email that, or CC me at mjthomp3@gmail.com. Agents who represent the seller should request that the seller initial and date all rejected offers and email a copy of the rejection to the buyer's agent. Right? This will prevent the buyer from questioning whether the offer was presented to the seller. So when you send over the offer, you put initial in that box, check the box of rejection, and then send it back to the agent so that they know that they know that the seller saw it, right? Again, agents who represent the seller should request that the seller initial and date all rejected offers and email a copy of the rejection to the buyer's agent, right? So this is the policy. So you get an offer, right? Your seller says, no, I don't want to do the deal. Well, you still need to get him to initial and sign it. So then you can send a copy to the buyer's agent, and this will prevent the buyer from questioning, did the seller actually get that offer? Well, yeah, because he actually had to sign it and date it, right? Escalation clauses. IMAV Realty realizes that escalation clauses have become a common occurrence and have been the subject of recent litigation. For that reason, the company discourages the use of escalation clauses when writing an offer. If the company is representing the seller, then it is highly recommended that if the escalation clause is unclear to the amount that the buyer is willing to pay, or we receive multiple offers with escalation clauses, then the seller should ask all buyers to present their highest and best offers without the escalation clause. Office facilities. IMAV Realty believes in the hybrid office model. IMAV Realty also has a cloud-based office where we hold company-wide training and teams are able to meet virtually in Google Classroom. Agency, type of agency, permissible or not permissible by the company. Permissible is going to be the company represents the seller landlord exclusively when we are the listing agent, but not the selling agent. The company represents the buyer tenant exclusively when we are the selling leasing agent and not the listing agent. The company represents both the seller landlord and buyer tenant as a dual agent. Limited representation disclosure form is going to be required. When there are two sales associates from the company, agency is established with the broker, not the sales associate. The agent should send an email to the client explaining what rights they are waiving and receive an acknowledgement or have it in writing and have the client sign it. Listing compliance procedures. IMAV Realty agents are responsible for ensuring that each listing file is submitted via email to mjthp3@gmail.com and is in compliance with ADRE and company standards. In addition, agents are also responsible for entering listing data into the MLS. Agents failing to submit complete and timely files or violating MLS listing regulations will have their data entry privileges suspended or revoked. Agents must submit all listing documentation in accordance with the required documentation checklist found in our agent portal section of Google Classroom. All documentation must be uploaded to Google Classroom and emailed to mjtw3@gmail.com. You have 3 business days within 3 business days of the effective listing contract date, as stated earlier. The broker will revoke listing data entry privileges in the case of agent noncompliance. In the event an agent loses listing data entry privileges, in the case of agent noncompliance, a $50 charge shall be charged to the agent for each listing needed to be entered by management. So, if you need management to put in the listing, you're going to be charged $50. Sales compliance procedures. Management is responsible for file certification, compliance, quality control for all sales and rentals. Sales agent is responsible to ensure that all sales and rental files are properly documented and fully executed. Once a property is under contract as a sale or lease, agents must submit all sale rental documentation in accordance with the required documentation checklist found in the form section of Google Classroom, or from time to time we may use www.paperlesspipeline.com. All documents need to be uploaded to Google Classroom, or from time to time we use paperlesspipeline.com. Within 3 business days of the effective date. From time to time, the company broker may use paperlesspipeline.com or Google Classroom for all documents to be uploaded into. Post-closing procedures. Agents are responsible to hand deliver, courier, or mail to the office the following documents items within 24 hours of closing or rental lease signed. The closing statement or the HUD-1 for purchases, a walkthrough inspection, IMAV Realty buyer or tenant, commission checks, all checks payable to IMAV Realty. Failure to do so may result in the agent losing the privileges of getting paid at closing. Rental deposits. IMAV Realty does not maintain an active escrow account. All rental deposits should be made out to the property management company. Commissions. IMAV Realty strives to pay commissions in a timely fashion to our agents, but also must make sure that the files are complete and legible. Missing documentation will delay compensation. In general, commissions will be paid within 3 business days of the date that the management receives the final file documents, including the closing statements and checks payable to IMAV Realty, and the file is complete and checks have cleared IMAV Realty's commission account. However, commissions may be paid at closing under certain circumstances. Agents must get authorization from management to be paid at closing and must notify management in writing a minimum of 2 days in advance of the closing. Management must have complete files and have received sufficient advance notice of closing at least 2 business days. Agents must get authorization from management to be paid at closing. So if you want to get paid a little earlier, you have to put it in writing to the escrow company or title company, and then they can pay the agent. But you have to put this in writing, and it has to be every single transaction. Because typically, it takes agents some time to get all the documents together, and you got 3 days after the close of escrow to give it to your broker, and then the broker has 3 days to pay you with, after you've provided them with all the documents from the checklist. Negotiated commissions. The company realizes that from time to time the agent may be required to negotiate the real estate commission due to competitive market conditions. This is perfectly acceptable and does not require prior broker approval. However, our policy with reference to negotiating commissions is as follows. Agents are not permitted to advertise in any way that the company is willing to discount, reduce, or rebate commissions. This can be done privately between realtor and customer, but never publicly in any media. So don't let me catch you having a Facebook ad out there where you're offering 1%, 1% commission. We typically do 3%, but if you have to do some negotiation, that's perfectly fine. Commission concessions or credits by IMAV Realty agents must appear on the closing statement. When IMAV Realty is the listing agent, the cooperating broker, not the agent, must sign the commission concession authorization. If this is not signed by the cooperating broker, the IMAV Realty agent may be liable to pay the cooperating broker the commission concession or credit. If the agent has 80% mentorship commission program plan, any commission arrangement that results in IMAV Realty getting anything less than the 20% or 3% of the sales price will be charged back to the agent as a commission differential fee. So, so typically it's based if we're on an 80-20 split, and you meet with somebody and they talk you down going from a 3% payout to 2% of the sales price. Well, that's going to reduce my 80-20 split as well. So any reduction is going to get charged back to the agent on what they receive. Alternatively, if you sell another agent's listing and the listing commission provides for a commission to our office for less than 3%, the office will not assess a commission differential fee. Reductions at the closing table or other concessions will not lower the commission basis to determine company splits. Limited service listings. Agents shall not take limited service listings where the agent does not represent one of the parties and no fiduciary relationship is formed. Agents are not allowed to be paid solely for putting a listing on the MLS. Agent-owned properties. Agent may not practice single agent dual agency when the agent or a family member is a principal to the transaction. Agents may not enter into a contract to sell or flip a property until the agent holds title to the property. So again, agents may not practice single agent dual agency when the agent or a family member is a principal to the transaction. Agents agree not to act as a middleman in a real estate transaction when selling an agent-owned home. The agent agrees to provide a standard home warranty to the buyer at the agent's expense. Agents must disclose in all advertising, including listing, signage, print, media, or any other forms of advertising, that the agent is a principal to the transaction. Commission split program. There's a 100% commission program. Associates will receive 100% of the earned commission minus any past dues, invoices, or expenses. In order to receive the 100% and earned commission, associate agrees to pay by credit card $97 per month, every month beginning the day the associate joined. So the recurring payment will be debited on the same day in the following months until the broker or associate terminates this agreement. Payments will be made promptly to the associate only after the broker has received a complete rental sale file. If the associate is not current on their monthly dues, the past due amount will be subtracted from any earned commission. All monthly fees are due on the same day of the month the associate joined and are considered past due 5 days after that date if payment has not been received by the broker. It is the associate's sole responsibility to ensure all payments are made on time and to immediately report to the broker if a problem exists with the associate's monthly payment method. There is no late fee or charge for the associate's first late payment. However, if late payments become habitual or occur more than once, the broker will charge an additional $97 for late fees and charge to cover administrative expenses. There is a quarterly E&O fee of $35 automatically billed to the credit card on file each quarter on the 1st of January, April, July, and October. Referral policy. External referral policy. Brokerage company referrals between brokerages must be in writing. A referral form can be found in transaction desk. These referrals require broker signature. So say you get a referral from somebody, usually we pay out 30% referral fee. You get the referral document in transaction desk in AAR, Arizona Association of Realtors. Internal referrals. Internal referrals between agents within IMAV Realty are negotiable between agents and must also be established using the broker referral form agreement found in transaction desk. For this type of referral, the agent's signatures will suffice and the form must be filled out and sent to management. The commission split to the agent who referred will be based on the plan the agent who received the referral is on. Company-generated referrals. The company may generate customers through a lead generation program. Agents assigned leads will be assessed a 25% to 50%, 10% for rentals. Additional commission split above their normal commission plan. Agents is not required to take company leads. Relocation referrals generated by company agreements with relocation services, corporate relocation programs, etc., will assess the agent 10% above whatever the relocation agreement requires the company to pay. All referral forms must be signed by the broker. Agent support. IMAV Realty provides multiple layers of support. However, agents are expected to do their own diligence and be familiar with all the following support options. Broker and management involvement on a transaction. If an issue arises and an agent needs broker management to get involved in the transaction, commission shall be 80-20 split. So 80% to the agent, 20% to the broker or the manager. So again, if an issue arises, an agent needs broker or management to get involved to the transaction, the commission shall be 80-20. It's a big deal because oftentimes depends on what you're helping with, but if you have to get involved in any kind, you're at 100%, it's going to go down to 80-20. Problem resolution protocol. External. The Board of Realtors. Association and Board of Realtors exist to support and assist agents. As professionals, agents are expected to remain current with their board's MLS policies and regulations. Boards are also excellent resources offering professional seminars and workshops. The Board of Realtors will provide technical support for MLS issues. Internal. Email. This is the preferred communication between the agent and the principal broker. General manager, also a qualifying broker or assistant to the general manager. Agents are responsible for summarizing their situation and forwarding an email to mj2w3@gmail.com. Brokers respond to all emails within 1 business day. Direct contact. For urgent situations, please contact the appropriate staff member, management, or broker by telephone. Your yard sign procedures. All agents are independent contractors and are responsible for their own business expenses, including yard sign installation and removal and repair costs. IMAV Realty maintains contacts with sign installation companies to support agents. Each agent is responsible for ordering yard signage directly from the sign installation company and ensuring the signage is provided to them. IMAV Realty will provide agents with vendor contact information to order personalized signs. E&O claims. IMAV Realty maintains errors and omissions insurance to defend both the company and agents. However, agents are responsible for defending any legal, administrative, state, federal, or agency actions brought against IMAV Realty regarding any real estate transactions they were involved in. E&O insurance does not cover business transactions unrelated to real estate. For E&O insurance claims, agents must pay any deductible. Commission disputes, arbitration, non-E&O claims, agents will be fully responsible for any legal and filing fees. Professional association designation. All PAs, professional associations, are provided IRS Form 1099 from IMAV Realty. Do not call rules. Agents must stay up to date on rules relating to the National Do Not Call Registry. Cold calling must be done in compliance with applicable state and national laws. Any fines that result from any violation of the Do Not Call law or any other solicitation will be paid for by the agent who broke the said rule. Contact info. Agents must use their legal name as it appears on their real estate license, in all advertising, on contracts, and in all real estate correspondence. Agent's business address is the main office in Arizona, located at 139 North Carter Ranch Road, Coolidge, Arizona 85128. Agents must use this address in all real estate activities. All business correspondence related to transactions must be sent to this address, not to the agent's home. No personal mail may come to the office. Any mail coming to the office will be considered official business and subject to being opened by the broker or admin team. Agents agree to make arrangements to pick up any parcels delivered to the office by vendors and will work to promptly inform all vendors that parcel deliveries are to be scheduled directly with the agent. All unclaimed parcels are subject to disposal within 7 days of delivery. Company holidays. IMAV Realty has defined corporate holidays where all offices will be closed. These holidays are as follows: New Year's Day, Memorial Day, Independence Day, Labor Day, Thanksgiving Day, the day after Thanksgiving, and Christmas Day. Confidentiality. All company information is considered proprietary and strictly confidential and should not be duplicated for the purpose of distribution to third parties. Intellectual property rights. Agents shall become familiar with and adhere to all laws, rules, and regulations regarding intellectual property rights and their real estate business. Intellectual property refers to all major forms of legal protection of tangible rights protected by the law, including copyright, trademark, patent, trade secrets, design rights, and the like. Agents shall acquire, use, and deal in only licensed copies of copyright protected material and genuine articles of trademark and patent protected products in carrying out the agents' and companies' businesses. Solicitation. Agents will not directly solicit, market, or recruit for any reason whatsoever any other agent within the IMAV Realty Group and IMAV Realty Organization during this agreement or for a period of 5 years after the termination of this agreement. So basically, you got 5 years after you quit here to, you start your own brokerage to get other agents to work for you. Antitrust compliance. Sales associates and employees must take special care to avoid discussion with employees and sales associates of competing firms regarding the commission policy of the company that could be construed to be agreements or conspiracies to fix, establish prices, or otherwise restrain competition in violation of state and federal antitrust laws. Omissions from policy manual. Associate and employees. Any item or procedural issues not covered in the manual are subject to state, brokers, and company approval. Any item not covered and decisions rendered are final and are to be made at the sole discretion of the company. Termination. Upon termination of the agent's affiliation with the company, any pending escrow shall be closed by company and compensation therefrom, minus the company splits, fees, expenses, including but not limited to reassignment fee, as determined by a company from a transaction coordination fee at then current rates per transaction, shall be deducted from the agent's commission. Listings and pending transaction files shall be released at the sole discretion of the company. As used herein, good standing means that the agent is not in breach of any term, covenant, condition, obligation, or duty set forth in the agreement, has no pending legal claims or disputes, and his or her license with the State Department of Licensing has not been restricted, suspended, or revoked. Company reserves the right to withhold commission and assign another agent to close out any pending transactions. Agent's agreement shall also immediately and automatically terminate without prior notice if for any reason agent breaches his or her obligations hereunder, or if agent license expires, is restricted, suspended, or is revoked. In the event agent leaves the company, their termination date will be determined by the date the notice was given by either party, as referenced in the independent contractor agreement. Agent billing shall continue unless written notice to off-board was delivered to company by agent or agent was terminated by company. Any prepaid fees, dues, or other billable items are non-refundable. Upon termination or separation from the company, agent will lose access to all company tools, emails, files, and company-provided third-party sites. The company strongly encourages agents to back up any files they desire access to prior to requesting offboarding. If within 12 months from the termination date, the agent wishes to rejoin IMAV Realty, the agent must have left in good standing. Policy and procedure update and review. The company reserves the right to make updates to its policies when or if updates are made. They will be communicated through company meetings and through email. Agents will have 7 days from notice to review changes and seek clarification. At the completion of the 7 days, the changes will be deemed acceptable. For IMAV Realty, the Policy Manual by Michael Thompson, who's the broker and the owner. All right, so also incorporated within this agreement is the Policy Manual. So for IMAV Realty Brokerage, IMAV Realty sets the following procedure guidelines, which are for the conduct of doing real estate business. This manual shall be attached to and made part of the broker associate independent contractor agreement freely entered into by both the broker and the associate. Associate is the realtor, real estate agent. In the event a situation arises that is not covered herein, the broker's decision will be final. The manual may be amended from time to time as events warrant, and associates will receive a copy of any amendments. IMAV Realty, number 1, may within 1 to 2 years provide and maintain an office for broker. Associate and associates clientele. Number two, will not tolerate or be associated with the use or possession of any controlled substances, drugs, firearms, explosives, contraband, or anything determined to be illegal or on any property listed. Will remain a general business phone number, which will be answered 24/7. Any listing or advertising by associate must include the general number and a direct number to that specific associate. Number four, may take listings in any lawful form approved by broker and may offer sub-agency to cooperating brokers, but will fully accept buyer broker participation. Number five, will require associate to input listing according to MLS or ARMLS rules and regulations. All associates must be approved by the broker to all associates must be approved by broker to input listings. Also, broker or appointed coordinator must approve and review the listing within 48 hours. The associate is responsible for correct and accurate information. Any changes by the seller must be in writing with the change form and approved by the broker within 48 hours. After approval, new printouts must be changed into listing book. Any and all non-MLS listing must include written disclosure by the seller that property will not be advertised in the MLS, a $100 charge to the associate's commission if the broker has to make or input changes on behalf of associate. Number six, will follow Article 26 of the Arizona Constitution that grants or allows the real estate broker and associate the privilege to draft without charge any documents incident or necessary to a real estate transaction. With that privilege comes the responsibility and duty to explain the implications of those documents. Always encourage the advice of an attorney and or an accountant or any other professional associated with the real estate transaction for the benefit of your client. Requires associates to use the most recent standardized published forms established by the Arizona Association of Realtors AAR contracts and reserves the right to approve, edit, or reject or add any documents used by associate as deemed appropriate by broker. So what this says, you need to use the most updated AR forms. All completed contracts, listing, or transaction must be submitted to broker within 3 business days of final signature or rejection. All sales transaction must run through a title company unless all parties secure legal representation. So again, unless all parties secure legal representation. Earnest money funds receipt from the title company or legal representation shall accompany each purchase contract. All earnest money funds must be written in title or escrow company name. Don't write it in the brokerage name. Number 9, will not restrict the form of representation associates may offer to the public. Each associate is responsible for knowing and explaining the benefits and consequences of the form of agency employed. So again, each associate is responsible for knowing and explaining the benefits and the consequences of the form of agency employed. In all cases, all parties to the transaction shall be made aware of the form of agency chosen. Where mandated by law or other applicable regulatory agency, written confirmation shall be made available to all parties to a transaction prior to execution of a binding document or in a manner consistent with the law. Number 10, expects all its associates to be familiar with and responsible with all disclosures and disclosure areas. So WQARF, CERCLA, lead-based paint, swimming pool, super fun, airport noise, etc. Knowing the location, you have to disclose location if you're near an airport. Supply buyers and tenants the proper disclosures when applicable. So ask the broker. Expects all associates to be responsible for all fees and expenses, including maintaining an active state of Arizona real estate license and membership in the Arizona Association, AR, National Association of Realtors, NAR, and Multiple Listing Service, MLS. Will maintain Arizona Missions insurance for the coverage of all transactions allowable within the policy definition. A copy of the policy is available upon request. Each associate is responsible for payment to the brokerage of the required claim contribution immediately upon demand, in accordance with the commission split at the time. If multiple associates are connected with the transaction leading to an E&O claim, each is individually liable to remit the required contribution. Contributions offset costs of services provided by the broker, counsel, and other necessary expenses, and are considered non-refundable. Each associate agrees to cooperate fully with ownership and management in resolving complaints or litigation. Each associate is personally liable for any claim or loss exceeding E&O policy limits or not covered by it. Associate liability survives severance. Each associate grants the broker's express permission to withhold E&O claim contributions from commission or other income payable upon written notice of a potential or actual claim delivered to the associate. E&O and applicable fees will be assessed for associates connected to any transaction. E&O will be charged on all transactions. Transactions over $750,000 and commercial transactions will be charged a premium of 10% for additional E&O coverage, right? So the more expensive the property, the more E&O we have to charge. So if it's over $750,000, additional 10%, right? Because that's what they're going to charge us. Commissions are divided between the broker and associate as outlined in the commission schedule of the independent contractor agreement or the policy manual. Will pay referrals to licensed brokers only and only with a W-9 from the referral brokerage. A copy of the license and ID number must be received within 30 days or referral will be forfeited. All transactions, sales, purchase, rentals, leases, exchanges, etc. must be submitted on time. If a broker receives a closing package missing proper contract forms, associate commissions may be delayed and result in severance. All transactions must have the correct check sheet attached to transactions at the time stated herein. Commissions will be dispersed to associate within 72 hours during regular weekly business hours of receipt of closing package with all applicable items on a check sheet provided and reviewed by broker or broker coordinator. So, after the close of escrow, you got 3 days to give all the documents to the broker. Broker has 3 days to pay you after they've received all documents. If they don't get all documents, then it can take longer. All closing packages must be delivered to the corporate home office. Do not fax transactions under any circumstances. All transactions are to be emailed to mj223@gmail.com. All advertisements must be reviewed and accepted by the broker prior to releasing advertising. All buyers must review, accept initial date, and be given a copy or buyer attachment information, including but not limited to buyer inspection, mold, termites, roof, agency disclosure, etc., etc. This form should be reviewed at the time of purchase or prior to that time. A copy of this cover page of the residential resale real estate purchase contract must be in the package for review when submitted to broker within 5 days after buyer signs this contract. All associates who are unable to serve their clients for any reason must make arrangements for another associate to manage their business during the absence. So, say you go on vacation and you can't, you have a listing, you can't do anything, you need to assign someone else to do it. Also, there may be extenuating circumstances where family members may inform the broker of an associate's absence. The associate must inform the broker, coordinator, or management in writing of the identity of the other associate managing which transactions within 24 hours of the absence. If the broker, coordinator, or management is required to become directly involved in a transaction as a result of the associate's absence or neglect, 50% of the commission owed to the associate will be forfeited to the designee along with applicable fees. So again, right, if you're on an 80-20 split and of that 80% you made say 10 grand and the you had to get another agent involved, assignee, well, half of that 10 grand, 5 grand is going to go to the other agent for picking up your slack. This brokerage does not promote and will not tolerate any type of discrimination, including but not limited to race, color, creed, religion, age, sex, disability, etc., of any kind at any time by an associate. If an associate is accused and or convicted of any kind of discrimination, that will be grounds for immediate termination and they will be severed from this brokerage. So if you discriminate, you're not going to be part of the brokerage. All associates must sign and date a W-9 IRS form and keep the broker current on their address. If any associate quits, resigns, or is terminated, they do not receive any further compensation other than transactions already in process. So, if you have a deal, so you list the house, right, and it's listed, right? No one, it's not under contract. As soon as it goes under contract and it's in escrow, then you have earned your commission, right? But if you just have listed the property and you're just waiting for somebody to get an offer, it's not in process yet. It's not in escrow yet. Once you have a buyer and you've accepted the offer and you have the seller and the buyer and they've both signed it and they've accepted the deal and it's in escrow, now it's already in process, right? That's when you're entitled to your commission. All newly licensed or non-experienced associates must be mentored by the broker or an appointed mentor for the first 3 transactions. The mentor will receive 20% of the above-mentioned associate's compensation for the training. The mentors must complete the entire transaction. Mentors must complete the entire transaction and follow through. An example is provided. So, example for the first 3 transactions with mentor. Sale price is $200,000. The commission is 3%. So 3% of the $200,000, that's $6,000. The split, 50%. 50% is to the lead. Okay. 90% is for the agent. So the mentor with experience knowledge gets 20%. Right, so 5,400 times the 20%, that's 1,080. The gross commission before the expenses, 4,320. The transaction fee, you have to pay E&O insurance. Transaction fee is $595. What's paid to the new associate realtor? $3,725. Okay, this is with you not getting the lead, right? Typically, if you generate your own lead, it's 80-20 split. Associates may sell or buy their personal properties with 100% gross commission minus E&O insurance fee and a transaction fee for a total of $595. Personal property is limited to associates, titled and recorded personal or investment properties. Associate properties must be in a county recorded title for 180 days or more. Less than 180 days would be considered flipping and not be covered under E&O insurance. All associates will hold harmless IMAV Realty. All such transactions are to be treated the same as any other transaction with the same documentation requirements regardless of the circumstances, i.e., listing agreement. If representing a client in a for sale by owner property, a commission agreement with the seller must be in place prior to offer contract submittal. So here's the commission structure. We have 90% plan, 90% gross commission plan, a 60% gross commission plan, a 30% gross commission plan, and we have a 5% gross commission plan. So 90% is on self-generated transactions minus a $595 transaction fee. 60% is minus the transaction fee on company generated. So if the company gives you the lead, you'll get 30% gross commission as a showing agent referring. We have a 5% gross commission plan if you act as a recruiting agent. So if you find another agent and they close the deal, if you find other agents, you get 5%. So, and there's also, if you don't want to do a percentage, you can do a flat fee listings. So company generated transaction, it's $750 with no transaction fee. And self-generated transactions, if you find the deals, you can be paid a flat fee minus the transaction fee of $595. If there's listings over $750,000, that's going to require an E&O premium of 0.1%. All right, so if you want to sell your own house, let's go back to here, you can get 100% commission, right, if it's your own property. Now, regarding associate owners selling or buying their own properties, it is the policy of IMAV Realty that if an associate has not completed the first of 3 transactions, that the agent must use a mentor for selling or buying their own property, and this transaction shall not count as one of the 3 transactions. So, say you just became an agent and you want to sell your own house, but you need 3 houses, right? You're a new agent, you need 3 houses at least to be with a mentor. Your house will not count as one of the 3, right? In that regard, the mentor shall be compensated a fee equal to 20% of the commission advertised and are based on 3% of sales price, should no commission actually be generated on behalf of the agent. The new associate cannot be reimbursed for school fees for selling or buying their own properties and must pay for their own signs. Also, an associate will be limited to 3 residential properties per year. Any more than 3 and any other type of property will be negotiated on an individual basis only with the broker. So again, if your broker or management has to step in with your transaction, it automatically goes to 80-20, right? 80-20. And if it's on your own property and you got to get your other broker involved, it's going to go to 80-20, 80% to the agent, 20% to the management or the broker or the mentor. Okay, so associate signs and the representative or the broker sign clear. All right, so we'll go over the information and the reference page. So the information and reference page here. So associate will put their name, address, city, email, For commission checks, the 1099 or social security number, it's for the 1099. So we can give you a 1099 miscellaneous at the end of the year and tell you how much money you made with the company so you can provide it to your certified professional accountant for taxes. Auto insurance name, home number, work number, cell, fax, date of birth, office number. For emergency purposes, we need you to fill out two